Good morning. I'm Peter Romeros, and I've represented the husband, Coy Bentley, throughout the course of the matter. I'd like to reserve 5 minutes per rebuttal, if I could. We are here today to describe two very distinct, or several very distinct, specific legal issues that the trial judge, we believe, erred on in very distinct matters that I'll discuss with you. We're not here to argue facts as it relates to whether or not there were facts to support this, that, and the other, except to the extent of the failure of the wife in this case to carry her burden of proof. Number one, we believe that when the judge determined this to be unenforceable, he didn't consider in the manner that he should have the undisputed testimony of the wife taken in the light most favorable to her, which is completely and totally dispositive of all of the issues in the case. The testimony is straightforward and relatively amazing, to be honest with you. Number one, she testified she never signed the document. Secondly, she testified she never read the document.
Well, I mean, look, just to fast forward, the trial court ran through, didn't find her very credible on it, said, yeah, you signed the document. The issue really is, did she get, under the other Castos factor, did she get a complete disclosure? Did she really or fully know what it was that she was signed to, which is a unique facet of these these postnuptial marital agreements?
Yes, sir. The reason her testimony is critically important does relate to that specific issue. And the reason it relates to that specific issue is that how can you possibly claim prejudice, which is the actual test? Concealment and prejudice are the tests as it relates to failure to disclose. I'll get into that in a minute. But you can't claim prejudice when you claim you didn't read the document, you didn't sign the document, and had you read the document, you would have never signed it. How can that possibly be something that's consistent with a claim of prejudice? That was the reason I was going to go through these detailed findings. Under any set of circumstances, the key, as you correctly pointed out, is was there a failure to disclose that resulted in prejudice and or concealment? In the Del Vecchio case, which is cited in the Casto case with approval, there's a very telling quote which specifically says, the basic issue related to non-disclosure or lack of disclosure, if any, is concealment, not the absence of disclosure, and the wife may not repudiate if not prejudiced by the lack of information. The bottom line here is that what occurred unequivocally, without any dispute, is that she did sign the document. The judge determined it to be a valid document, not a document that was in any way subject to duress, for the benefit that she received under the terms of the document, that is the home that she wanted. And under that set of circumstances, you simply may not repudiate a document with complete absence of any prejudice whatsoever. The trial court applied the wrong legal test in attempting to apply some equity, which is always something we try to do in family law, but under this circumstances, the legal test was simply wrong. The judge, in his order, determined the legal test to be that the division of assets clearly favored the husband, number one. That's not the test in any prenuptial or postnuptial agreement. Number two, that the overwhelming majority of the assets go to the husband. Once again, that's not the test in any premarital or postmarital agreement related to reliability. What you must determine, and what Casto and Del Vecchio say, is you have to have specific findings that the agreement is disproportionate to the means of the defending spouse. Now, and they go on in there to say that even if there hasn't been a full and complete financial disclosure. Now remember, in this agreement, it states in numerous times that they did discuss it. They knew all the facts and circumstances. The wife testified to that effect. But the judge here could not make a finding by any means that this agreement was disproportionate to the means of the defending spouse because there's no evidence on it at all.
We didn't have any financial affidavits?
No, sir. There was absolutely no evidence whatsoever related to, at the time of the signing of the agreement, that there was anything disproportionate. Remember that although percentages were applied, 10% to the wife, 90% of the husband, 10% of zero is still zero. 90% of zero is still zero. And the test really relates to what existed at the time of the agreement. As stated in the brief in detail, there was no effort made whatsoever to carry this burden of proof. To the contrary, Mr. Berg, Todd Berg, who was the neutral CPA, and this is cited in the record, and is referenced specifically in a detailed argument, had prepared a specifically neutral determination, a summary of what assets existed at the time of the agreement to show that it was or wasn't disproportionate as the burden requires. In this case, not only did wife's counsel not offer that into evidence or elicit any testimony concerning it, he objected to the document, stating that it was something that was asked to be prepared by one side, this, that, and the other. Judge overruled his objection. It was a document that, had it been used, we might not be here at all today, but it wasn't. Instead, there was no evidence whatsoever to establish anything disproportionate in the way of the financial determination made by the prenuptial agreement. Now,
I want to make sure I understand your argument. When you say there was no evidence ascertaining the assets or the value, you mean solely as of the date that it would have been executed, not as of the date that they were actually, because there was plenty of evidence about what the, as far as what kind of value was going on with in terms of by the time we got to the hearing, correct?
Absolutely. There was some evidence, not a lot, but there was some evidence. But the test is clearly, it's in Del Vecchio, it's in other cases that I've cited, the test is clearly the disproportionate nature of the assets at the time the agreement was entered into. There's no doubt that that's...
So your position is that because the hearing occurred sometime later than when the PMA was executed, that is a failure of evidence as to value at the time of execution.
Yes, sir. There was no evidence as to the value of the value of the assets at the time. Now, remember that this is what we're trying to do here when we're dealing. We have a contract between parties, and as we know, this is a family law case. It's a little bit different than other contracts, but what we're trying to do is make sure there's no concealment. We're trying to make sure that there's no prejudice. And the reason that prejudice and concealment are the tests is because a person, as it states in Casto, they can enter into marital settlement agreements for lots of reasons that are totally unfair. I want to get divorced. I don't care about the finances. That's in all the cases. I don't care how unfair it is. But if they know what they're getting into, it's a binding agreement, just like an agreement to buy a car at a price that's outrageous. It's binding. Here, there is not one word of testimony to establish anything unfair or unreasonably disproportionate to the means of the defending spouse at the time that agreement was entered into, and they completely failed to carry their burden of proof on that issue. There is no basis for the agreement to have been set aside. The judge, again, as he did in Schliffstein, which is another case with Judge Hellinger that I was involved in, simply trying to do the right thing in his mind and rewriting the agreement because he felt it was unfair, that's not the way to do it. That's not why we're here. This is an agreement that was completely binding and should be enforced. Thank you.
May it please the court. I'm Brandon Vesley from the Florida Appellate Firm, and I represent, with pleasure, I represent Coy Vaughn Bentley, known as Tutu. Your Honors, I think the first thing that I need to hone in on and focus on is the fact that the test here is competent substantial evidence, whether the judge's findings are supported by competent substantial evidence, because the judge very carefully went through the Casto factors and very carefully applied the test. So if his findings are supported by competent substantial evidence, this court must affirm. So let's talk about the issues that were raised. The first issue was the agreement fair and reasonable? But I have to point out the language from the Casto test, because the Casto test very clearly states that the challenging spouse must show the agreement is unfair or unreasonable given the circumstances of the parties, must present evidence of the parties' relative situations, including their respective ages, health, education, and financial status, and then with that information, that basic information, a trial court may determine that the agreement on its face does not adequately provide for the challenging spouse and consequently is unreasonable. So, we have in the record their ages. We have in the record that they're both healthy. We have in the record and in the order that they both graduated from high school and had some college. We have in the record how they started their businesses together, and we have the financial status. So let's talk about the financial status. They had, according to the evidence that was presented at trial, they had this is at the time the agreement was entered, okay? So it was established during the course of the case, through the evidence, through the testimony, what they had at the time the agreement was entered. They had two profitable nail salons, 3 income-producing rental properties. They had Bentley Equities, which was a commercial property where Royal Palms was located. They had Northeast Jewelry Exchange Corporation, a collateral lending company. They had their business furnishings. They had their home furnishings. And they had a personal bank account. And they had several corporate bank accounts and even a gun collection. These are the assets that they had at the time the agreement was entered. So, in order for the court to determine whether it was fair or reasonable, the court needed to look at the terms of the agreement. Counsel, in his briefs, never once mentioned what the terms of the agreement were. Never once mentioned the breakdown between the husband and the wife and how it was disproportionate to her. Never once mentioned how unfair and unreasonable this agreement truly is. So let's talk about that. So under this agreement, the wife is going to receive 10% of the net value of the real estate, 10% of the net value of the contents of the marital home, 10% of the net value of the tangible assets held by the businesses. So we're talking about furniture, tools, appliances, inventory, etc. 0% of any stock in these companies, 0% of any funds held in the corporate accounts, which she had no access to, 0% of any interest in any business that's not reflected in stock. She does get 50% of their personal bank account. Of course, she doesn't know what's been put in the personal bank account as opposed to the business accounts. And she gets to keep all of her jewelry, which the agreement talks about as being non-marital. He gets to keep his jewelry. She gets to keep her jewelry. And she gets to keep her vehicle, which they pointed out in their brief was a very nice vehicle. But unfortunately, she owes a ton of money on it. It's got a huge payment due. And he has an indemnification in the agreement that she doesn't have to pay for, he doesn't have to pay anything towards her very expensive vehicle. So that's what she gets. He gets 90% of the net value of the real property, 100% of the businesses that the parties established during the marriage, 100% of the corporate accounts, 100% of any stock the parties own, 90% interest in the net value of the marital home and its contents, 90% of the interest in the net value of the tangible assets held by the businesses, 50% of the joint bank account, his jewelry, and his vehicle. And then it gets really crazy because this agreement says that her 10% of these, assets, first, he can take her 10% and pay it to his mother to satisfy this promissory note of $280,000, her share of it $140,000. So she's going to have to use he's going to use her money that he would give her as her 10% to pay his mother. And then in the event that anything is left over, he gets to stretch it out over 10 years, paying 120 monthly payments with 0 interest. So the court looked at that, and on its face, it's very unfair, and recognized that they didn't have nothing at the time this agreement was signed. He wants to talk about how she came into the marriage with nothing. This agreement was signed 5 years.
I don't think that's his argument. I think his argument
it's in his
where was his argument for today, oral argument. I think what he's saying is, look, there was no evidence about what those assets were what their value was at the time of the signing of the agreement. So we have, in other words, there was no way for the court to determine that this, I hear what you're saying about the disproportionate numbers, but if we don't know what those percentages were based off of at the time of the signing of the agreement, can the trial court really reach the conclusion it reached? I think that's, if I understand your friend's argument today.
Your Honor, we would respond and say that you don't have to have the specific dollar amount figure of the value of those assets as long as you know that there were assets and as long as you know that the assets had some value. And the value is substantiated throughout the entire case, that they had value. I don't have a specific number. There was never a specific number given.
At the time of the signing of the agreement?
Yes, I read them off. I'll read them to you again, Your Honor.
But where in the record would I find someone saying that, the date of the agreement signing escapes me for the moment, but where will I find in the record, these assets were worth roughly, approximately, or they had value when the agreement was signed? Where would I find that in the record?
There is no valuation of the assets in the agreement. The only thing that we know is that there were assets. And so her percentage of the assets is substantially unfair to her.
But
Okay, so that's our
we're
point.
kind of going around. 'Cause, for example, let's say we're
No, I
talking about some
understand.
businesses. I open Lucas LLC, right? Today I open it. I don't open a bank account. I don't put any money in it. It's just an LLC. 10% of that is worth nothing because 100% of it is worth nothing. Now later on, maybe Lucas LLC, I grow it, I make a ton of money with it. Hooray! And 10 years down the road, okay, Lucas LLC has some value, but really the issue is what was its value at the time we signed a post-marital agreement, or in that respect, it would be, well, the non-disclosure doesn't matter because it wasn't worth anything back then.
Well, Your Honor, I don't believe CASTO requires that. It requires you to show
So
the
you're
financial.
challenging the premise, his underlying premise that the disclosure is tied to the date that the agreement is signed.
No, I'm challenging this premise that I have to put a valuation, a dollar amount on these assets.
I don't think he's saying to the penny. I think he's saying, look, what evidence is there that it had value at all?
There was evidence that these were profitable businesses. There was evidence that they had money in the bank. There was evidence that
At
they
the
had...
time of the signing of the agreement?
Absolutely, yes, and that they had bank accounts at the time that she didn't have access to, so she didn't know how much was in there, but there was bank accounts.
Can you
You don't
point me
have
to-
bank accounts with $0. You don't have businesses that are profitable that are worthless.
Can you point me to the record where I could go and find that, okay, here's where it is shown that these businesses, these assets had some kind of value, whether we're talking about if there's a real estate parcel, it wasn't completely underwater, no, it had some equity. If it was a business, no, it was going, it was generating customers, there was revenues at the time of, that this was signed, such that we could say, yeah, there was some concealment of value here.
It's in the husband's testimony. I think if you look on, I'm going to give you a number of pages because I think there's a lot of different points in the transcript that talk about what they had at the time. So let's go with, it's an appendix, so it's A. Pages 162, 177, 178, 211, 296, 297, 279, 160 through 164, 167. There's just, there's so many different
Well,
places.
some of these, I recognize some of these, and some of these really just concerned what the value, it's not clear what the date of value, it looks to me like they're talking about the date of value at present, at the time of the hearing. That's not what I'm asking. What I'm asking is where in the record would I find some kind of evidence where it says, hey, at the time she signed this agreement, these assets that weren't disclosed, they did indeed have value.
It's in, apologize, Your Honor, wasn't expecting this question.
I throw a curveball every time.
No worries. We'll find it for you. Excuse me. Yeah, again, this is the value of the businesses at the time. 162, 177, 178. And again, we challenge the premise that you have to prove a specific dollar amount. That does not seem to be what is required.
It's not in Casto, you're right, that's not in Casto. What Casto says is that she has to have enough knowledge where she could obtain a value through reasonable means. That's what we have to
And whether
be
it's
sure.
fair on its face, which means looking at the document itself and saying, is this a fair
That's the
distribution?
preliminary, yeah, the analysis, that's the preliminary inquiry of the analysis. Then you proceed to, it's B, then you get down to the second ground, under B of the second ground, which is that, look, did she have a general and approximate knowledge? I think, I hear your point.
Well, and
Look, 10%, no alimony. It looks to be on its face, which is what you're supposed to look at for that initial determination, whether or not it's fair and equitable. I hear exactly what you're saying. I think what most of this argument is really revolving around is that latter part of the analysis. Look, did she know enough such that she had a general idea of what the assets of the marriage were?
And that's their burden. And that's not her burden. That's the husband's burden, because he's the defending spouse.
Yeah.
And he has to come in and he has to show by clear and convincing evidence that she had full and frank disclosure. And if she didn't have full and frank disclosure, which he admitted she didn't, he didn't give her any documentation or anything, then she has to have a general approximate knowledge of the challenging knowledge of the character and sin of the marital property sufficient to obtain a value by reasonable means, as well as general knowledge of the income of the parties. So, as to the second argument, Your Honor, whether he fulfilled his burden in that regard, the trial court made its detailed findings that he didn't. And the court focused on the Casto and the Hortas case and compared them to this case, and they were very similar in their facts. And then the court said that he failed in his burden, and the court and the evidence that was presented at trial, the testimony and the evidence that was presented at trial supported his finding in that regard. And that's because at the time, this is all at the time, the husband admitted that the wife at the time had no involvement with any of the businesses or their rentals properties that they owned in 2010 except the salons. And her involvement in the salons was she worked the front end and he did all the finances. She handled, she paid the staff and she ordered supplies, but he handled all of the finances. He knew what the electricity bill was, and he was in charge of the business. And she didn't have access to the business checking account. You know, she had to ask him for money if she was going to do those things. And that was the same with all of the businesses. He ran the show from the beginning to the end on all of the business aspects of the businesses that they owned. And she had no access to the business records. She testified that in 2010 she had no understanding of the value of the businesses or the rental properties that they owned. I'm repeating these things from the record because I want to show that there's competent, substantial evidence to support what the trial court found. The wife testified that she had no way of valuing the businesses because she did not know the income or the debts associated with the businesses. The husband agreed that the wife had no understanding of what any of the businesses were worth at the time she signed the PMA, and that's on page 211 of the record. The wife further testified that despite her limited involvement in running the salon, she had no understanding of the value of them. Wife testified she did not discuss the value of the salons with the husband. Wife testified she did not know what was being deposited into the joint checking account by the husband other than her paycheck. The wife testified she did not know the husband's income from the various businesses or what he did with it, with the other business distributions. She testified she did not have access to the business or corporate accounts. Both parties agreed that the husband handled the bank accounts and the credit cards, and the wife did not review those accounts. There's ample evidence And they claim there's piles of financial disclosure, financial documents at home. The husband admitted that he never told the wife or suggested to the wife that she review the financial records that were at home in the office. The wife testified she did not ask a lot of questions concerning the finances. She was aware that there were some financial records in the home, but she never thought to go through them. The parties never discussed reviewing financial records prior to the PMA. So, Your Honors, the fact is that, again, we're dealing with competent substantial evidence. Are you going to uphold the judge's ruling that she did not have the requisite knowledge? And the evidence, though, you could have more, you could have less, but there's enough there that you have to find that there was competent substantial evidence to support that ruling. So he briefly mentioned this ratification of the postmarital agreement argument, and I just want to make a couple points on that as well. So the argument goes that they were looking to buy a house at the time they signed this agreement, and he's arguing that that was her dream house and that therefore she signed this agreement as a result. But that makes no sense based on the facts of the case. And the reason why is because there's nowhere in the language of the postmarital agreement that the purchase of the Water Hyacinth house is contingent upon the wife signing the postmarital agreement. Even if it was a benefit of the PMA, it was the husband's benefit, because if it was enforced, he gets 90% of it and she gets 10% of it. So that doesn't seem to fly with her ratifying this totally lopsided agreement. And further, the mother's loan that allegedly paid a portion, but not all, of the $280,000 towards the house, but paid a portion of the deposit or the down payment on it, was not contingent upon her signing this agreement, and the mother was not a signatory to the agreement. And most importantly, she wasn't a signatory to the agreement. So I submitted a case in a supplemental authority, the Kearney case, and that case talks about how you can't ratify a marital settlement agreement if the benefits under the not marital settlement agreement, postmarital agreement. Again, we're in the middle of a marriage here. You don't accept the benefits of that if it's something that you might be entitled to as part of your marital interest. And you can still then, at the end of the case, and when the case is filed, you can still challenge that agreement. In that particular case, the wife was asked to sign an agreement in the midst of their marriage where the husband was running a business and she had to sign off on her interest in the business in exchange for $3 $1 million payments. She took 2 of the $1 million payments and they filed for divorce. He said, well, she ratified it. She accepted my payment. She deposited them in her bank account. And the court said, no, she might have been entitled to that anyway as part of her marital distribution, and for that reason, we're allowing her to challenge it. And she got to challenge it.
I need to advise you, counsel, your time has expired.
Time has expired. Thank you, Your Honors. I just want to say just one last thing. Judge Hellinger wrote that this situation is a poster child for how not to have a valid postnuptial agreement. We agree with Judge Hellinger, and we would ask the court to affirm and find that the agreement is unenforceable. Thank you.
Thank you.
Let me answer a couple of your questions, Judge Lucas, directly and unequivocally. In the answer to the question, where in the record do we find any evidence to substantiate what the net worth or the incomes of the parties were at the time of the agreement? The answer is nowhere. There is no document, no record support whatsoever for that issue. And even worse than that, it's important, if you have an opportunity, to look at Appendix 50 through 55, which describes what did exist to establish that, and their failure to even offer that into evidence or attempt.
Why does that matter? Because under the Costa, I'll never say it right, under the guiding case, you have the burden of showing that she, in fact, had knowledge of a value, whatever the value is. If it's valueless, it's valueless. You got to show it. If there's a value there, you got to show it. The absence there, how does that help you, given that the burden shifted
With
to
all
you.
due respect, Your Honor, that, if you've got that a little bit backwards, I respectfully
You
say.
think
and
that wasn't, you think
I
it wasn't
feel,
unfair
but-
on its face
but
because there was no testimony of value?
Let me just ask you to take a look at footnote 2 of the Casto case on second or third page that describes specifically that it is their burden, in fact, to show that the agreement is unreasonable. And it goes through in detail. You can, as you said earlier, you can establish that it's unreasonable on its face by looking at the document itself. But then it goes on to specifically say, and this is by the challenging spouse, must prove, in making this determination, the court must find that the agreement is disproportionate to the means of the defending spouse. This finding requires some evidence in the record to establish a defending spouse's financial means. Additional evidence other than basic financial evidence may be necessary to establish the unreasonableness of the agreement. Clearly and unequivocally, once you get to that point, they have the burden of proving that it was disproportionate to the means of the husband in this case. They didn't do that in all. No testimony whatsoever to support that. Why is that critical?
Well, there was some testimony to the effect that he always ran the business. He was the one with the money.
Well, there's
She
no
kind of
evidence.
came along later.
There's no evidence to establish a disproportionate distribution of assets. Matter of fact, there's no evidence to establish what, if anything, existed. The issue of the timing that it is to be determined as of the time of the agreement is specifically dealt with in Casto in footnote 3, where it says the test in this regard is the adequacy of the challenging spouse's knowledge at the time of the agreement. It's later specifically stated in the Hortus case, which is a case they cite in their brief, that specifically says, in that case, they proved $2 million to zero as far as at the time of the agreement. And what they said, and in that case, the agreement was held to be not supportable. A comparison of the net worth of Philip and Gail at the time of the execution of the contract, $2 million to zero, is reflective of the power that he had. Here, there is not one word of testimony to establish that anywhere. Just briefly, as it relates to the ratification issue, clearly somebody taking what was a marital asset as a part of distribution doesn't ratify the agreement. What occurred here, and it's very contrary to what the counsel said. He wasn't at the trial, I understand this. I know he didn't specifically misstate this. Read paragraph 12 of the judge's findings. He specifically ties directly in to the execution of this agreement, the loan from the parents, the purchase of the home, the fact that the wife wanted the home. That's a huge issue as it relates, not necessarily to ratification, but prejudice. This is an agreement that was entered into freely and voluntarily by two people who knew what they were doing and should be enforced, and the judge should be reversed. Thank you very much.
Thank you.